Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to cover the case of the Queen in Wyville, which is another case on this jurisdiction issue that's happening across the country right now. Several people have asked me, can you cover this one as well? And so I'm going to dive right in. Now I'm going to skip over as much of this case as possible in the interest of time. If you haven't watched my video on the Queen or on the Stark decision, then I suggest you do that because it will provide a lot of the sort of procedural background here that otherwise I'm going to skip over and you might miss. So I'll try to link that right here. And continuing on to Queen in Wyville. Just as a starting point, there's a little bit of introduction, and we see that Mr. Wyville is in his 30th year with the Canadian Armed Forces. He holds the rank of Lieutenant Commander in the Royal Canada Navy. The reason why I mention this is because it really illustrates a bit of who this law is targeting. Because it's not really going after criminals. Criminals aren't running around with a whole bunch of AR-15s. But these are popular rifles with people who are military veterans or active military. They're also popular with police. And they're popular with people who engage in certain sport shooting disciplines. So when you think of who we want to target, 30-year military veterans is not really our primary focus, or at least I hope it shouldn't be. And so, I mean, 30 years is a lot of service to the country, and this is the thanks he gets. So I guess that's my political commentary for this particular video. So they note as well, the firearm associated with the registration certificate is a Colt M4, an assault-styled firearm. Now, I don't know what assault styled means, because assault style essentially means gun I don't like in the words of most people. It doesn't have a clear definition. It's a term that sounds scary, but has a lot of flexibility to apply to whatever gun you don't like at the time. So when we see the judge using this language, it already tells us where we're going. Like, I don't know a firm definition for assault style firearm. Like, I know what Memphis style barbecue is, but yeah, I'm not a fan of the terminology that we see being used here, but that's not really a legal issue here. That's just a personal annoyance. And frankly, it's language that I think should be avoided as much as possible, because it's useless. This is just scare terms. So they continue on. Sometime between July 22nd and July 24th, 2020, Mr. Wyville received from the Registrar of Firearms a correspondence dated July 20th, 2020, and entitled Firearms Registration Certificate Impacted by the Amended Classification Regulations. In the correspondence, Mr. Wyville was informed of the following. These firearms listed below are now classified as prohibited, and the previous registration certificates are automatically nullified and are therefore no longer valid, but should be retained as a historical registration record. So that's the sort of background here. I'm going to skip over a whole lot of this because, again, covered in a previous video, but if you haven't watched that one, you may want to. So position of the parties, this is what the two sides are arguing. Mr. Wyville, as the applicant, is of the view that the July 22nd, 2020 correspondence he received from the registrar, actually it was July 20th, he received it on the 22nd or thereabouts. The reason why this is phrased in this fashion is that this is actually a transcription of an oral judgment. So this sort of verbal tick or verbal sort of backtracking is because this was delivered live and orally rather than as a written decision. You wouldn't see this in a written decision. He received from the Registrar of Firearms was for all intents and purposes a decision of the Registrar of Firearms to revoke his registration certificate for his Colt semi-automatic rifle. As such, Mr. Wyville submits that he is entitled to a reference hearing before a provincial court judge pursuant to Section 74 sub 2 of the Firearms Act, as well as an order pursuant to Section 76 sub 6 of the Firearms Act, cancelling the revocation of the registration certificate. Counsel for the Attorney General of Canada is of the view that the July 20th correspondence from the Registrar of Firearms was not a decision to revoke the registration certificate, but rather it was a letter informing Mr. Wyville of the May 1st, 2020 regulatory amendments, which reclassified his Colt semi-automatic rifle from restricted to prohibited, resulting in his registration certificate being automatically nullified. I'll talk a little bit more about that in a moment. So counsel pointed out that the letter from the registrar also provided other information. So this would be counsel for the Attorney General, such as what is required of owners of newly prohibited firearms, the owner's options, the intention of the government to implement a buyback program, as well as an amnesty order which expires on April 30th, 2022. I'm not actually sure what the relevance of this is, because you can include other information in a notice of revocation. This one doesn't really seem to push things either way. But perhaps the court is just providing us with some narrative background, but I don't see how this really suggests one option or the other. So counsel for the Attorney General of Canada submits that the Registrar of Firearms did not decide to revoke Mr. Wyville's registration certificate as contemplated by the Firearms Act, as no decision was made by the Registrar of Firearms, as it was an order in council of May 1st, 2020, the regulations amending the regulation prescribing certain firearms as prohibited, that automatically nullified Mr. Wyville's registration certificate. Counsel for the Attorney General submits that as there was no decision to revoke Mr. Wyville's registration certificate by the Registrar of Firearms, Section 74 of the Firearms Act cannot be made use of by Mr. Wyville, so he is not entitled to a reference before a provincial court judge. Counsel for the Attorney General of Canada's position, more succinctly, is that I, as a provincial court judge, do not have the jurisdiction to do what Mr. Wyville wants done. So I'll talk a little bit about some of these arguments, but I'm going to save that for where these arguments are fleshed out a little bit more. So the background: the Ontario Court of Justice derives its jurisdiction from statute. Accordingly, a provincial court judge is only empowered to make orders which a governing statute authorizes. That's correct, and I'm going to skip over where he's quoting the relevant law here, because that's not really super interesting or important here. But they quote, and he's actually going to quote this multiple times, a paragraph from Pogson, which is, "It is not the function of a provincial court judge hearing a reference to fight some sort of rearguard action against gun control on the theory that the courts are better able than Parliament to balance the competing policy objectives." Now, to my mind, this suggests that Wyville, like other decisions, is really getting the question wrong. Because to my mind, the question here isn't, the point of this sort of these reference hearings isn't going to be to overturn the actual order in council, because that can't be done at provincial court. The question, though, is whether these notices are proper notices that conform with the legislated requirements. And, you know, if you stop and think about it, what if they're wrong? Like, what if they send you something and it says, we're revoking this because it's covered by the ban because we think it's an AR-15 variant, and they haven't even provided that much information. They just say it's covered by the ban. But let's say they've decided that your particular firearm is an AR-15 variant and therefore they want to ban it. But what if that firearm is a Sig Sauer P226, which is a handgun which has no connection to the AR-15 at all? Somebody made a mistake. Somebody goofed. Well, how do you challenge that? To my mind, that's the issue. Is, you know, did they get that decision right when they apply this law to particular firearms? And that is a very different question. That's not a rear guard fight against gun control. That's a front guard fight on the question of jurisdiction, or the question of proper notice and proper reasons, and the application of the law to the specific facts of a specific firearm. So that's a very different scenario, and it looks to me like the court is answering the wrong question. They're answering a question, and I don't know if that's Mr. Wyville was bringing the wrong question. I don't know Mr. Wyville. There's not enough information here for me to make that determination. But it might be Mr. Wyville's bringing the wrong question, or it might be that the Attorney General is muddying the waters in order to get the court to answer the wrong question and shut Mr. Wyville down. I can't say that from looking at this, but continuing on. And skipping over, there's a whole bunch of discussion here. They start making reference to the deadliest mass shootings, because the judge is saying, I'm not going to attack the underlying ban. And again, that is not the right question. But looking at their actual analysis of this particular thing, it starts off with the registration certificate that was nullified. He's assuming the conclusion here. That's a problem. But continuing on is, of course, that related to his Colt semi-automatic rifle. Mr. Wyville, in response to the correspondence received from the Registrar of Firearms, reviewed the order in council of the Criminal Code, or the Criminal Code and the Firearms Act, and he was unable to find any reference to or statutory provision that would provide for the nullification of a registration certificate. Accordingly, he was of the view that the nullification spoken of by the Registrar of Firearms is in fact a revocation of his registration certificate, which led him to conclude there are clear procedures and authorities within the Firearms Act that bound the actions of the registrar. Such actions are reviewable by the courts, and where such actions fall outside the bounds of the law, people such as the applicant must be able to look to the courts for relief. I agree with that. That seems, I mean, the Firearms Act restricts a lot of what I do as a gun owner. However, it also restricts the Registrar of Firearms and the Chief Firearms Officer. It puts certain duties and obligations to them. And so the question here is, have they complied with those obligations, or are they engaging in some sort of clever dodge to those obligations? And we'll see what the court finds. I can tell you what I think as well. So the Firearms Act notes the relevant provisions of the Firearms Act are found in Section 71 through 76. Section 71A, the registrar may revoke a registration certificate for a prohibited firearm or a restricted firearm for any good and sufficient reason. So that's the criteria for them revoking a registration certificate. And Section 72 says that they need to provide notice when they do so, and that the notice needs to include their reasons as well as information about how to challenge it. So that, I'm going to skip over reading it in its entirety, but that's sort of the brass tacks. And then he goes and repeats this, which again tells me that this judge is, and I'm not sure if it's the judge getting it wrong or the Attorney General getting it wrong or Mr. Wyville getting it wrong. Somebody's getting it wrong here, though, in terms of what the fundamental question is, because when the judge repeats, it is not the function of a provincial court judge hearing a reference to fight some sort of rearguard action against gun control on the theory that the courts are better able than Parliament to balance the competing policy objectives. This is the wrong question. Nobody, or at least I hope that's not what the issue is at the Wyville matter, but it's not properly the issue. The issue isn't we want to overturn the order in council. That fight is happening in federal court. It's being run by able counsel. There's various groups running various challenges. That's where that fight is happening. However, again, if they say that your SIG P226 is an AR-15 and therefore needs to, they're canceling that certificate, how do you fight that? Well, you fight that through Section 74. That's what the law says. And so when the court says, talks about some rearguard action against gun control, that's not the point. So continuing on, skipping over a little bit here, he says, as a provincial court judge, I do not have the authority or power to review the decision of the governor and council to change the law with respect to the classification of firearms. And again, I hope that's not what was being asked of him, but to my mind, it's not the issue. So as Mr. Wyville is well aware, there are several proceedings across Canada in the federal court challenging the constitutionality of the order in council, and he's made it clear that his issue is his lack of a registration certificate for a firearm. So this suggests, but doesn't tell me, that Mr. Wyville might have been on the right track on this one, but I don't know. I don't know what the arguments were. I don't have a full transcript of this proceeding, so I don't really know where things went wrong on this one. I can just see that they did. That's the main thing here. So Mr. Wyville understands that he is now in the untenable position of being in possession of a prohibited firearm he cannot use and enjoy, while the government lets him know what they intend to implement a buyback program, or more importantly, develop a grandfather regime, as was done for the CZ or SAN Swiss Arms. It is the state of limbo he believes can be alleviated having an order made directing that the Registrar of Firearms issue a registration certificate for his Colt semi-automatic rifle. And this suggests that Mr. Wyville was on the wrong track. And all respect to Mr. Wyville, he's running this on his own. It looks like it's very difficult for an ordinary person to navigate very complex issues here. But if the Registrar of Firearms issues him a registration certificate, he still can't take it to the range. He's got to know that. So, it's still a prohibited firearm. He's still not able to take it anywhere. So it looks to me like maybe he was asking for the wrong thing here. And that's ultimately a problem. So skipping on, they quote a whole lot of the sections again. It says, it can be readily seen that it is the decision of the registrar to revoke a registration certificate, along with the reasons for the decision, that is what is being referred to the provincial court judge. The Canadian Oxford Dictionary's definition of decide is come to a resolution as a result of consideration. Have or reach one's resolution about something, resolve or settle a question, dispute, etc. While the definition of decision in the Canadian Oxford Dictionary is the act or process of deciding, a conclusion or resolution reached as to future action upon consideration. And they say, it cannot be said in these circumstances that the Registrar of Firearms came to a resolution as a result of consideration to nullify Mr. Wyville's registration certificate. The Registrar of Firearms was not deciding, as the decision was made by the Government of Canada when it passed into law the Order in Council. Now, again, this is missing the point because there's two decisions. One decision, decision number one, is the decision to ban certain firearms. And that decision is the Government of Canada's decision, and is, of course, not reviewable in provincial court. But there's a second decision, and that second decision is how to apply that order in council to specific firearms in order to decide that those are revoked. And that decision should be reviewable. The court is looking at the wrong decision here. They're looking and saying, well, we can't review the Government of Canada's decision. But that second decision, they never actually get to. And that second decision is the one that really should be being looked at here. So that, I think, is, again, this case is missing the point. And I don't know whose fault it is, but it's missing the point. Moving on, they say the Registrar of Firearms was not engaged in the process of consideration of resolving a question or dispute over Mr. Wyville's registration certificate. The Registrar of Firearms had no choice in the matter as compliance with the law is mandatory. Mr. Wyville's Colt automatic rifle is no longer a restricted weapon, as SOR, well, the Order in Council has declared it to be a prohibited weapon. So the firearm registration certificate, which had been classified as restricted, is by operation of law nullified. Well, first, if you're saying that it's by operation of law nullified, show me the law that nullifies it. Because there is no provision for automatic nullification upon a ban. There just isn't. It's not in the Criminal Code. It's not in the Firearms Act. I've yet to see anyone, including... This is my own, reference, and these are the materials of the Attorney General on behalf of the Registrar. They don't point to anything that classifies as sort of an automatic nullification or automatic revocation, other than saying that you're not eligible to hold the registration certificate if it's prohibited. The problem is that the eligible language is used for everything. You're not eligible to hold a firearms license if you're a danger to yourself or others. So if saying that you're not eligible takes you outside of the Section 74 regime, then the Section 74 regime has basically just been entirely annihilated and written out of the Firearms Act, which in my view is not what the courts should be doing. If they want to get rid of Section 74, the place to do that is in Parliament, not in this court. So that's, I don't see how they actually get to that step. The court sort of assumes it, but show your work, please. I would love to see a court showing its work on this. And the only one that actually does show its work on this is Stark. And Stark comes to a very different conclusion because they went through those analytical steps. I mean, consider this. We have this Colt automatic rifle, which is actually a semi-automatic rifle. So, but that, again, that's not really the issue here. But what if they're wrong? What if they say, we think that this particular firearm, serial number, whatever, is an AR-15, and it's not? Where does that question go? Where do you get to challenge that issue? The Firearms Act says that should be in provincial court through the Section 74 process. They're missing that there's two questions, and they're pretending that it's just one question, and that's a big problem for all of these cases. They say, quite frankly, the July 2020 correspondence Mr. Wyville received from the Registrar of Firearms was an explanatory document, and it was aptly titled Firearms Registration Certificate Impacted by the Amended Classification Regulations. The problem is, saying that it's an explanatory document doesn't mean it's not a notice, because by definition, a notice is an explanatory document. I don't get the logic here where they say it's an explanatory document, but continuing on. The document cannot be said to be a notice of revocation of the registration certificate with reasons for that decision as contemplated by Section 72 of the Firearms Act. More importantly, it cannot be said that the Registrar of Firearms made a decision in this matter that I, as a provincial court judge, am entitled to review pursuant to Section 74 of the Firearms Act. Again, it sounds like they're pretending that there's only one decision here and missing the two-decision problem. So, continuing on. In this matter, a certain amount of time was spent on considering whether the Registrar of Firearms revoked Mr. Wyville's registration certificate as opposed to the registration certificate being nullified by operational law. Certainly, the words revoke and nullify are very close to being a synonym. In fact, many dictionaries list them as synonymous. As well, I understand Mr. Wyville's concern that nowhere in the order of council is the matter of registration certificates addressed, and that from the standpoint of Section 12.9 of the Firearms Act, he's concerned about potential grandfathering. Yet it is clear that Section 12.9c of the Firearms Act speaks of being a holder of a registration certificate on the day in which the firearm was prescribed, which, of course, Mr. Wyville was. The grandfathering question, I don't think, is the big thing here. Stark actually relies a lot on the grandfathering question. I think it's the wrong issue. I will cover the case that I think illustrates the correct remedy and the correct issue around this in a future video, and that's the case of the Queen and Cross. They say, I find myself in agreement with the two provincial court decisions, namely Judge Valente's decision from April 13, 2017, Queen and Gardner, court file number Thunder Bay 1, where he decided in that case that the Registrar of Firearms did not make a decision relating to a prohibited device amounting to a decision to revoke. There's a small problem with this. That case was overturned on appeal. So maybe not the best precedent when it's a case that was later flipped. That's just kind of my feeling on that. Also kind of the way the law usually works, but continuing on. Therefore, there was no decision to review allowable under Section 74 and 75 of the Firearms Act, and no remedy under Section 76 of that Act. Going into what Gardner is about, that was a case where somebody had a bullpup stock on a rifle, and so they revoked that. And, you know, they said, well, there was no decision on that, and the court found there was no jurisdiction. That jurisdiction issue was then reversed by a higher court, finding that the decision was made improperly, and because they had not allowed the calling of evidence on that matter. So the precedential value of a decision that was reversed seems to me to be very low. But continuing on, at least I think that that's the case that they're referring to. I might be wrong. It might be another one, because it seems that this is an unreported decision that they're referring to. But I believe that's the one they're looking at here. That kind of makes me shake my head a little bit. I agree entirely with the words of Judge Gorman. This is the Nova Scotia case, when he recently dealt with a firearm that had been reclassified from restricted to prohibited by, and I'm not going to cover those words because I covered them in a previous video, which hopefully I'll be able to link here. So if you want to see that, go ahead. Continuing on here, they say, as the Registrar of Firearms did not make a decision, I do not have the jurisdiction under the Firearms Act to consider a reference, and the application is dismissed. Thank you. So, and then there's a little bit of sort of back and forth. Mr. Wyville thanks the judge, which is proper. Even if you don't agree with the decision and you don't like it and you're planning to appeal it, you want to show respect to the court, and, you know, thanking the court for the verdict, even where you agree, you know, where you disagree with it, is a proper thing to do. So I'm not, you know, if you're saying, hey, you know, why is he thanking the court for this? You know, the court was, didn't give him what he wanted. That's entirely proper. It's good on him. It shows good character of Mr. Wyville. Again, I'm not sure if he made a mistake in the, you know, in conducting this hearing, but there's nothing to suggest that Mr. Wyville is anything less than a stand-up guy who cares about his rights here. So when I look at this decision, the main thing, again, is there's two decisions. And, you know, the registrar is not making one of them. One of those decisions was made by Parliament. But that second decision of applying it to a particular registration certificate is, in fact, a decision that the registrar is making. And that's the one that, in my view, is reviewable. And the court in this case and in the case of Mr. H seem to not really get that. And so I hope when my case comes up that I'll be able to make that point a little more succinctly. Right now I'm working on written submissions, so I may miss a few days of getting videos out because I think that case is actually a little more important than what I'm doing here. Not to diminish, providing legal education to the public, but I think it's a bit of a big deal. I'm going to, at some point down the road, once I've got sort of all my thoughts organized, explain what I think the stakes are in this particular issue, because I think it's a really big deal, and I think it's a bigger deal than the court in this case understood, and that the court in Mr. H understood, and even that the court in Stark understood. There are bigger issues going on here than any of these cases looked at. And I hope I can bring them to light in my upcoming case. I'm not sure if that's going to be possible because of some unusual procedural things that are going on. But anyway, I'll cover all of that in a future video, but I did want to give you guys a heads up. I may miss some days of getting videos out because that's an important thing. So thank you for watching. Please like, share, and subscribe. It really does help this channel grow. I really appreciate it. Once again, I think that the reasoning in this case just falls substantially short of the really high quality reasoning in Stark. I think that Stark is the preferable case, not just because it's the case I agree with, but just they go through things in a lot of detail there, and they consider issues that just aren't considered in these other decisions. These other decisions are very much, the Mr. H case, it seems fairly circular. This case, it looks like they're answering the wrong question. And unless the court is answering the right question, they're not going to get to the right result. That's my feeling on that one. So ultimately, as I said before, we've got all of these decisions going in different ways from different jurisdictions. I think this one's going to end up at the Supreme Court, and I really hope that the Supreme Court makes the right call on this one, because there's a lot of skin in the game for the average gun owner. And again, that'll be a future video because I don't want this one to be, 2.5 hours long. Half an hour is about the limits of people's tolerance, I think. So let's move on. As per usual, I want to thank my Patreon supporters at the $50 level: Demo, People of Canada, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, and Toronto Airsoft. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt. And at the $10 level, Ma Buddy Keith, Process Eng, Stephen Larson, General Counsel of the CCFR, John Robinson, TR, Roy Haddock, Frackles Jean-Alexandre Tessier, Sir Goat, Sights and Arms Limited, Chaba Hollow, Peter H., Craig Kwan, Akin Coxall, North Central Process Service, Toys R for Boys, Ian Vaughn, Milan Vrekic, Terrence Griffiths, Doug Thompson, Mark D., Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Michelle Stotzel, Scott Sweetman, Mike Rhodes, DF, Stacey Cartmell, Tactical Advantage TV Canada, Ian S., Dave Leslie, Juan, Donald Duncan, Darren Duell, Sean Crane, Ian Hutchinson, Rory, Travis, BC Bushcraft Leather, John Sangarty, Misa Komarevich, All Systems Go, David Moga, Ian Hedge-Danek, Hello from Venezuela, Taylor Delnea, Rod Guzman, Matthew Nesbitt, Conway Yuri, James Cox, Zip Ties and Bias Plies, I'm not sure if that's a reference to something, and Renji Malarkey. So thank you once again. I'll leave a link to the decision in the description below, as well as to the Discord and the Patreon. Thank you, and I hope this has armed you with knowledge. As I said, there's going to be more videos on the topic of this Section 74 thing because it's a big deal. So thank you once again, and see you next time.